constitutional law, I'm just recapping briefly, is a branch of public law, meaning it is concerned with your relationship with the state. In other words, with those accountable, democratically elected representatives who are there to serve our needs and our interests in terms of the Constitution. So, in order to make it more apparent to you what I mean, I have drawn a diagram. So at the beginning of your study guide is one version where I call it the diagrammatic representation of constitutional law. But I did update that diagram in the electronic version of tutorial letter 102. 102 is what you received in hard copy, but the version I sent you yesterday evening is more detailed, and it includes commentaries, let me say, of cases that there was no commentary on. And those are excessively important cases. So I do urge you to look at the 7 cases that are in the electronic version of this. There's 7 cases, but in fact, 3 of them deal with exactly the same principal issue. The first one on AfriForum is there really more for interest than for examination purposes. Then there are 2 interesting cases, both brought by the DA against the President and against the Minister of International Relations, and we'll discuss it now. And then, of course, we have the very recent decision of Corruption Watch and Nkosana. It's case number 7 in tutorial letter 102. So it's those 7 cases, let's say 6, because AfriForum I'm not going to discuss in too much depth, that are crucial to today's lecture, because they really do explain that it is these principal organs of state that have an obligation, a constitutional duty, to remain accountable to us because we constituted the National Assembly. Therefore, the members of the National Assembly must be accountable to us. And they, because they elected the President, who's head of the executive, they have to hold the President and the ministers and deputy ministers accountable and impose sanctions against them if necessary, because they are speaking for us. And then, of course, we know that the third branch, the Judiciary, is always available whenever anyone alleges that either the executive or the legislature has not complied with the Constitution. That's really the essence of constitutional law, is you need to know that constitutional law is characterized by certain fundamental concepts, being constitutionalism, rule of law, democracy, separation of powers. And if you interrogate those issues, you will find that there are recurring themes. Democracy, rule of law, separation of powers, constitutionalism, all of them necessitate that everything that is done in the state is done by our representatives, who are democratically elected, but they do so in a manner that is open, accountable, responsive, compliant with the letter of the law. So that's why your diagram starts with those concepts just sort of placed at the top of the page. Constitutionalism, just placed there. Because it is a concept that permeates everything else on that page. And what we mean by a state that is constitutional, like South Africa, is we mean it is a state where there is an entrenched supreme constitution. That means that the Constitution cannot be arbitrarily or too easily amended. It's entrenched. In order to amend it, special procedures have to be followed. Special majorities have to be obtained. So a minimum of a 2/3 majority needs to be obtained in order to amend the Constitution. Constitutionalism is also indicative of a state where there is a separation of powers, a real separation of powers. We have that. A constitutional state is one where the rule of law reigns supreme. That is how constitutional law in South Africa is understood. That there is, and always must be, absolute compliance with the letter, the spirit, the object of the law. Other features of a constitutional state are, does the state have an independent judiciary? Absolutely, in South Africa's context. So you'll see, we have all of these characteristics. Another very important characteristic of a constitutional state is that it is a state where human rights or respect for minorities are specifically guaranteed and protected. And we know that that's the case in South Africa because we have an entire justiciable Bill of Rights where the courts can say the rule of law dictates that two men of the same, well, two men can marry each other. Our Constitution permits that. So you're with me that if you know these requirements of a constitutional state, in your true and false questions, for example, or even in any scenario you're given, you should immediately be able to see, but hang on, something's wrong here. For example, if, for example, it says something about processes not being followed by Parliament, that's not only contrary to the rule of law, but it's undemocratic, because the whole process of having a national legislative forum at the national sphere, and even in the provincial sphere, is so that people who we elect into those positions speak for us and represent us and give effect to our best interests and our wishes, because we can't be there. So they have to make sure that they are acting democratically in the execution of their duties. So those are the defining features of a constitutional state, and that's why it's right at the top. And pretty much any case, if you are to describe, for example, is South Africa a constitutional state, there are hundreds of cases you could use as your authority. There isn't only one right or wrong answer about is South Africa a constitutional state. So that's why I'm emphasizing now that you need to know the definition, but you also need to know case law, the relevant case, to substantiate it. And that's what I mean for all your assignment and exam questions. In law, if you don't have authority for what you're saying, and when we say authority, we mean case law, provisions of a constitution, provisions of a particular law, your whole answer is weak. You're probably not going to get many marks. That's why every question says substantiate your answer with reference to appropriate authority. All right. So constitutionalism is right at the top of the page, showing us that what our parents who were involved in the transition from apartheid to democracy, what they wanted to see in this new constitution that we have, they wanted to see that we have all of these features I've just mentioned: supreme constitution, entrenched constitution, democracy, rule of law. And our representatives speaking for us in the early 90s said specifically, we want a system in South Africa where we do have a separation of powers. But they said, we think South Africa's unique history means that the type of separation of powers that is created in South Africa is equally going to have to be unique. And that's when, if you get any question on separation of powers, your first authority should usually be De Lange versus Smuts, which is at the back of your study guide. You'll see there I have cases and with a little extract. And I have, for example, the sort of seminal part of the judgment of De Lange versus Smuts, where the court said, in South Africa, we need to develop our own unique form of separation of powers, one that suits South Africa's own particular circumstances, one which is able to address the legacies of apartheid and colonialism, but not just address them in a slow fashion by saying, and when I say we here, by saying it's the court, that the court can't just say, oh, let the executive do what they please, let the legislature do as they please. But we need to have a court that is strong and stable and independent enough to be able to act decisively when it is urgent. And that's what the dictum of De Lange versus Smuts says to us. So now we're going to see that constitutional law shows us how that dictum has come alive. How for every action by the legislature that appears to not conform to the Constitution, we will see that our democratically elected representatives, be they the DA, EFF, UDM, COPE, that's why most of the cases you see are in the name of political parties, because they are speaking for us. And they then approach the relevant court and they say, we are not satisfied that there's strict adherence to the rule of law. If you don't address the scenario with urgency, what might ensue is what could be termed a constitutional crisis. If we see a recurring pattern of the national legislature ignoring the rule of law, which is why 5 of the 7 cases in your Tutorial Letter 102 all really deal with this principal issue of holding people to account, because those people are the ones we have put into power. So we, through our elected representatives, hold them accountable. So that's why constitutionalism at the top. Then, sort of in the middle, near the top, is rule of law. Rule of law is probably the most important characteristic of a real constitutional state, because it means, as it says, it means that in a state where the rule of law is respected, no one is above the law, not even the president. We are all equal in the eyes of the law. We are therefore all subject to the same laws. No one can be charged of an offense in terms of a law that does not yet exist, because the rule of law says the law must already be clearly stipulated so that we all know what's expected of us, and we must act in terms of that law. And of course, sort of back to the point I was making in De Lange versus Smuts, when our Constitution was drafted, and in the certification judgment, the Constitutional Court said we need to make sure that we have a real separation of powers, but equally we must have a process of judicial review. And that is where to interpret the meaning and content of the rule of law, because very often, I mean, the Constitution is an example of this. The law itself just says there must be procedures put in place. That's not really enough guidance to us as to what the law actually means. And we have given that power to the judiciary. So we have an excessively strong, independent judiciary in South Africa who, in terms of Section 172 of the Constitution, do have the right, and in fact the responsibility, to declare any law or conduct invalid, and they can tell the legislature, you have made a mistake. Go and rectify the mistake. or they can tell the executive, you have violated the rule of law. So the point I'm making in terms of understanding what constitutionalism means, understanding what the rule of law means, even understanding what democracy means, is that of the three branches of the state, the judiciary has what seems to be more superior or stronger powers than the other two. But that is perfectly legitimate. So you've all heard of the Counter-Majoritarian dilemma, and I gave it to you in sort of picture format, and it's now in electronic version of 102 that I gave you yesterday, because I need you to recognize that our entire system of constitutional law allows the judiciary to be that strong and to be able to say to the executive and the legislature, your conduct is invalid. So I think, let me wait a little bit before we discuss counter-majoritarian dilemma in more depth, because I think you have a fair idea anyway. But just using that diagram. So we've discussed constitutionalism, we've discussed rule of law. And then you see in the bottom corner there, well, near the top still, but democracy. And I say there are 5 forms of democracy. Do you agree that at all times in South Africa, there are at least 2, maybe 3 forms of democracy operating simultaneously? At all times, we are a constitutional democracy, which means that at all times, the executive and the legislature must comply with the law. And if they do not comply with the law, the judiciary can declare that they haven't complied with the law. We are also very much a representative democracy. So the entire process of the elections taking place tomorrow is pursuant to the notion of representative democracy. Because we are going to the polls to choose the political party who we want to represent us in the legislature, and we know, because we have a closed list proportional representation system, that when we cast our votes tomorrow for the national government and the provincial government, we are doing so because we want the persons of the political party of our choice to take the majority in the legislature, at national sphere or even provincial sphere, because we are convinced that they are going to be able to formulate policies and implement laws that will serve our interests best. So it's a closed list, proportional representation, democratic system, because there are 48 political parties contesting, and in order for the 400 members of Parliament to be duly and legitimately appointed, each political party is awarded the number of seats in Parliament out of the total of 400 in proportion to the number of votes that the party obtained. So we know if we want the ANC to have a 2/3 majority, they need to get at least 270 out of the 400 seats, just round about there, because otherwise it's going to be difficult for them to, for example, change the constitution. So that's how the votes are translated into seats. It's a proportional amount, and there is a calculation that is done where each vote is worth 2.1%, and then sometimes the denominator sort of falls away, and one extra member of a political party will be there. But the process is, as far as possible, an open, accountable process. That's why before the elections, the lists of each political party are published so that we know roughly who we're voting for, even though we aren't voting for those people per se. We are voting for the party, and these are the people in that party who will then give expression to our needs and our interests. Very interestingly, now I want you to be aware of this if you're not already. But as soon as the votes have now been counted and the political parties have obtained the majorities they've got, then the number of representatives in terms of that proportion of votes assume their positions in the national legislature. So it will become the 6th Parliament, because this is the 6th national election since the end of apartheid, and this new Parliament will then be constituted. Might be a whole lot of new faces, and they take their positions, and then what happens on that very first day could be an example of direct democracy. So those 400 people are sitting there speaking for us. It's as though we are all speaking into their ears saying, say this, do this, because they need to be aware of what we want and give effect to that. They then hold their own election, the 400 of them. Why do they do that? They do it to choose from within those democratically elected representatives the person who will then become the head of the executive and head of state. So that's why we know if the ANC wins a clear majority, it's going to be Cyril Ramaphosa. We have a pretty good idea that that's how it's going to be. Could be completely different. But all we know is that our representatives will give effect to our wishes because they will vote for Julius Malema if the EFF wins the majority. And so that's how democracy works. But the issue is that you need to understand that then when Julius Malema, let's use Julius, as soon as that vote has happened, where the 400 directly vote for their person they want to become the next president and head of executive, that person vacates office of the legislature and he then moves into the realm of the executive. So then someone else from the bottom of the EFF's list, not the right at the bottom, but the next one down, that person fills Julius Malema's place in the legislature. So there's always making sure that there are 400 people representing the political parties in line with the number of votes they obtain. So the legislature then is responsible for formulating laws, repealing laws that are now antithetical to our democratic dispensation, for amending laws. So they've got quite a lot of work to do. And they do all of that in terms of their duty to represent us. What they also have to do, and this is the third then form, I suppose the fourth, because we can include direct democracy there, but the fourth form of democracy that then becomes operational is, are you struggling? Oh, participatory democracy. Participatory means we have a right and actually an obligation to participate in the functioning of the legislature in order to make sure that our best interests are given effect to. So when a new law is being passed, Parliament will publish that fact, and they say, on the 12th of June, we are having a debate in Parliament. We are now calling for submissions from interested persons about this new law. The law that we are, for example, the law on expropriation of land without compensation. You can't sit back and say, oh, I'm not interested in being participating, and then complain afterwards if you don't like the outcome. You're supposed to have, well, I know we're all busy people, but you're supposed to be interested in what's going on and say, I actually think we should write a formal representation saying this is the way we think it should be done, so that you are participating. And I emphasize participatory democracy because you will have seen in cases like Matatiele and Mirafong where the provincial legislature, acting democratically, takes decisions and resolves to move Matatiele from the KwaZulu-Natal province to the Eastern Cape province, and where we saw that in the Merafong case, the Gauteng legislature said, well, let's just move Merafong into the Northwest province. And was that a real participatory process? No, because what happened is the government officials would come along and say, this is what's going to happen. And the people would say, we don't want this to happen. We are going to fight it. And then the government would say, well, it's going to happen. That's not participation. That's just dictating to you, imposing a decision that's already been made, and you haven't been given a fair opportunity to comment. And that's why Merafong was described as ungovernable, a war zone. The people said, we will render this place ungovernable because we object in the strongest terms to the fact that we were not taken into account in this decision. We refuse, in the Merafong case, to become part of the Northwest province when we've always been part of the Gauteng province. So that's the fourth form. The final form of democracy that's really subsumed within the others is that we are, well, yes, constitutional was the first one. We're a multi-party democracy. What were you saying? Multi-party, yes. I thought you said something else. We're a multi-party democracy. And this election tomorrow is the epitome of a multi-party democracy. The fact that we've got 48 different political parties to choose from. Okay, so that's democracy. And of course then in the middle then, and I've tried to make it in bold so that you really realize this is important, is the concept separation of powers. So all those forms of democracy that I've discussed are central to ensuring that the legislature, the first branch, operates optimally. But equally so, because we have empowered those representatives in Parliament to vote for the executive, head of the executive, we're also saying to Parliament, we trust you. Choose for us the best candidate to be the president of the state. Because why is it so important who the president is? It's important because as head of state and head of the executive, probably more importantly, the president is the one who gets to choose who he wants as his ministers, who he wants as his deputy ministers. And those important public officials are then ultimately responsible for making sure that all the laws that have been drafted by the legislature are implemented. So some of you, or maybe all of you, are doing administrative law simultaneously with constitutional law. Administrative law is really only that small pocket of looking at how the lower level executive branch, at the sort of grassroots level, how they are implementing the laws. So it's where you walk into the Department of Home Affairs to get your passport. That's administrative law. Because here it is an official who has been empowered by an enabling statute or an empowering act to determine whether you are eligible for a passport and then obtain the fees from you and give you your passport. But constitutional law is the bigger picture, because constitutional law is not just looking at those low-level functionaries who do make mistakes, and that's why you're learning about the mistakes and how to remedy them in administrative law. What we're looking for in constitutional law is generally how the executive functions, and we are more concerned with high-level accountability. In other words, how do you hold the actual minister accountable? Not just the low-level person in this Department of Social Welfare who doesn't want to give you your social grant because they want to steal your money, for example, or for whatever reason they give for not giving you your grant. We are really concerned with these democratically elected. We have to say it seems undemocratic that they're elected by the president who doesn't consult us, but through the whole pre-election process where we are members of a political party, we engage in meetings, we try and talk to the leadership saying, we want this policy, we want that policy, we want Julius Malema as our president. Generally, our hopes and wishes will be reflected in the actions of the representatives in Parliament when they're choosing the executive. And therefore, we hope that the president will choose the best minister of social welfare, the best minister of water and environmental affairs, the best minister of international relations. Because these people have ultimate responsibility to be open, accountable, responsive to our needs. So that's the executive branch. And therefore, as soon as the president has been voted upon or chosen, he vacates his position in the legislature, and then he's got to be formally sworn in as the President of the Republic. And that's done by the Chief Justice. So Mogoeng is going to be, and that's, again, you see this balancing of powers, where the judiciary is making sure that that process is legitimate, and that the representatives in Parliament will make sure that the right person was elected, and it's seen to be a largely democratic process. And at all times, then, we have faith that then the executive in place will do its very best for us. And if they don't, we know that the judiciary is there as the backstop. They are always ready and willing and able to tell the executive, you're not complying with the law. So separation of powers literally means precisely that. Do we have the three branches of the state that are independent and autonomous and have their own functions, but is there enough checks and balances and accountability mechanisms built in to make sure that they all do actually comply with their obligations in terms of the Constitution? And at that point then, if you look at your diagram, the top right, I have just the simple heading, Chapter 9, Institutions. That is because these representatives of ours who are in the executive, who are implementing the law, who are giving effect to the policies of the state, the public protector is watching. We've seen this now abundantly clear with Thuli Madonsela, even now with Busisiwe Nkwebane. These are now public protectors that we can trust, we can respect, because they have taken their constitutional obligations seriously. And what are their constitutional obligations? Well, now Busisiwe's is, in terms of Section 182 of the Constitution, to at all times have sufficient power to investigate any allegations of abuse of power, maladministration, corruption, any untoward or irregular conduct in the executive branch. And the public protector has the power to not only investigate, but we now know, as a result of the EFF1 case, that she can now even formulate binding recommendations. They're no longer just a recommendation, you can ignore them if you want to, as was the case before. We now have a situation where binding recommendations can be handed down by the public protector, and they must therefore be implemented. Otherwise, what's the point? It's just a waste of money, a waste of time, and it makes a mockery of the rule of law. If you have a constitution that says a public protector can do an investigation, she does her investigation and everyone ignores her findings. And then the second Chapter 9 institution I've listed there is the IEC. Those two are really the only two we really can or need to concern ourselves with in constitutional law. Because without the IEC, none of our systems would be truly democratic. Because the IEC, as its name indicates, is an independent electoral commission, which works throughout the 5 years before the election on making sure that registration takes place on time, that the voters' roll is updated, that there are the venues to conduct the elections, that the ballot papers are done, that the political parties are duly registered, even though they did make a fatal mistake with the BLF. But they generally get it right. They do generally do it properly. So we can trust that the elections will be free, fair. There won't be any, stuffing of ballot boxes, as happens in many of our neighboring countries. So those are the fundamental concepts that permeate constitutional law. And then, and I suppose I need to say this because I've had a lot of queries of late of this. So you'll see then I've drawn the national sphere, and I've put a sort of a circle around it, and then there's the provincial sphere with a circle, and then there's the local sphere with the circle. Those circles are the spheres, and what we mean when we say that in South Africa we have spheres of government and not levels of government is because levels of government is the concept that was used during apartheid, where quite literally, because the national government was so hell-bent on implementing its policies the way it wanted, it didn't give any independent or original constitutional powers to the local level of government. Everything the local level did was under the dictation and prescription of what the national level wanted them to do. And the minute they acted outside of that, they were told, sorry, you've got no more powers, we're going to intervene. Sorry for you, Mr. Mayor, you're now no longer the mayor of this little town. We are taking over. That's not democratic. And that's why, when our constitution was drafted, a conscious decision was taken to formulate the spheres of government, indicating that each of those three spheres have original constitutional powers that cannot be taken away from them. And even when there is a conflict between what the local sphere and the provincial sphere may want, there are clearly articulated rules in the Constitution about how such a problem should be resolved, so that you don't have to keep rushing to court and wasting money resolving this matter, but that the system known as intergovernmental relations and cooperative government, that's why Chapter 3 is termed cooperative government, how they can cooperate and talk to each other and say, okay, yes, the local level will realize we actually made a mistake. Our law did violate certain fundamental provisions of the Constitution, and therefore we're quite happy for our law to be declared invalid and for the original provincial law to prevail. So we are going to come to that. That's at the bottom of the page. So everything I've just told you so far is explaining the diagram. Because if in the exam you can see that diagram in your mind, hopefully it will make you realize that, okay, that this is what the executive is supposed to do. They haven't done that. Where do you go? You as a political party, for example, or a representative of a political party, might know that it's going to cost a lot of money to go to court, and it's going to take years. So instead you say to your leadership, I know that the public protector has sufficient power to be able to declare that what the head of the executive has done is unconstitutional. Let us go to the public protector and make our case instead of having to go to court. So that's what you must be aware of, is that often the question will be something like, where would you go that you think is going to be quickest, easiest, cost-effective, and actually give you the desired outcome? But the public protector has such power. So that brings us then to the discussion of the cases in Tutorial Letter 102. And I suppose a way of explaining why I included the AfriForum case. I included AfriForum because